Good morning and welcome to today's press conference on the release of Looking Back to Move Forward, Resolving Health and Environmental Crises. My name is Stephen Reed. I'm the Deputy Communications Director for the State Energy and Environmental Impact Center at NYU School of Law. And I'm pleased to introduce Scott Fulton, President of the Environmental Law Institute, and David Hayes, Executive Director of the State Impact Center. Scott Fulton was selected as the Environmental Law Institute's 5th president in September 2015. Previously, Mr. Fulton was a partner at the environmental law firm Beveridge and Diamond and served as general counsel of the U.S. Environmental Protection Agency, assistant chief of the Environmental Enforcement Section of the U.S. Department of Justice, Environment and Natural Resources Division, and in a number of other high-ranking government leadership positions. David Hayes is the executive director of the State Energy and Environmental Impact Center. He was deputy secretary and chief operating officer of the U.S. Department of the Interior for President Bill Clinton and President Barack Obama. He is an adjunct professor at NYU School of Law, a former distinguished lecturer at Stanford Law School, and a graduate of the University of Notre Dame and Stanford Law School. Before I turn it over to Scott and David, please note that you can submit questions at any time during the press conference using the Q&A feature. And now, without further ado, I'll turn it over to Scott Fulton.
Great, thank you so much, and good greetings, everyone. Welcome to the launch of this important new contribution to knowledge and scholarship around the role of litigation and settlement practice in shaping environmental and public health solutions. It's very much been our privilege at the Environmental Law Institute to be involved in the birthing of this book, Looking Back to Move Forward, Resolving Health and Environmental Crises. The Environmental Law Institute is a 50-year-old think and do tank, if you will, committed to building effective governance and rule of law in the environmental space, and doing so through knowledge transfer as a publisher, educator, researcher, and convener. And so when David Hayes and the State Impact Center reached out to us in 2019 about partnering with ELI Press to publish a book on lessons learned from some of the mega litigation in the past with particular focus on settlement practice, we enthusiastically said yes, as we saw this as very much in keeping with the best traditions of the Institute in endeavoring to shine a light on law-based solutions to environmental and public health problems. As it happened, 2019 was ELI's 50th anniversary year, and our golden anniversary theme was building on the past to secure the future. So as you can see, this book, Looking Back to Move Forward, fit perfectly with our own focus. We were also invited to contribute a chapter to the book, which we were most pleased to do. Our chapter looked at the experience from asbestos mass tort litigation, a particularly thorny area that has much to say in terms of the challenges that appear when courts are thrust into a policy void because of the failure of legislative approaches, with legislation ordinarily being seen as the preferred path for addressing broad policy issues. Some of the features of the asbestos problem echo strongly in some of the other 7 case studies examined in the book. For example, asbestos-related health impacts, principally lung disease, have long latency periods and are complicated by other risk factors, including smoking. And the nature of the risks were often hidden from the victims, with manufacturers withholding information about health impacts for decades. Once the scientific understanding of the attribution of various diseases to asbestos exposure became very clear and very public in the 1960s, tort cases began to be filed to address the public and business sector failures that exposed a wide range of workers to asbestos, especially during World War II and thereafter, resulting in a public health crisis of asbestos-related disease, disability, and death, which continues even to today. That litigation experience, which helped introduce the era of multi-district and class action litigation, is the largest and longest running mass tort litigation extending over 5 decades. It's fair to say that the tort system struggled mightily to accommodate the difficulties posed by proof of causation and statute of limitations requirements, particularly given the long latency periods and the multi-factor causation of the diseases. The tide began to turn in the early 1970s with judicial recognition of strict liability as the operative standard in dealing with ultra-hazardous materials like asbestos, a concept that would prove a powerful animator in some of the other contexts examined by this book as well, including Superfund. But even still, many roadblocks were encountered in this area, including great difficulties in the court system and just administering this massive litigation, processing the vast number of claims and the like, and the role of bankruptcy in limiting the liability of leading asbestos firms and blocking the path to complete compensation of losses and harms. The bottom line, we think, is that the tort system did transfer at least some of the burden back to responsible parties and did provide at least some compensation to many of the victims. But it did not fully achieve the goals of compensating victims in an equitable, complete, timely, and efficient way. Many thanks to my team who put this chapter together: Sandy Chum, Carol Jones, Cynthia Harris, and Sam Koenig. Very nice job, folks. But this is, again, but one of 7 case studies in the book. So many other hands were involved as well in its production. So I want to turn things over to David to mention the other contributors, discuss further details of the book, and describe the very helpful synthesis chapter that ties it together. I'll stop by just saying once again how excited we at the Institute are about this project and the book, and to add my praise to the praise of many others, including luminaries like Senator Sheldon Whitehouse, Massachusetts Attorney General Maura Healey, Kenneth Feinberg, Nora Engstrom, and Alan Kanner. Together, we salute David Hayes and the State Impact Center for their leadership in bringing forward this important and insightful resource for attorneys, judges, policymakers, advocates, and interested citizens as they grapple with the challenges of tomorrow. So over to an iconic presence in the environmental community and a great friend of the Environmental Law Institute, David Hayes. Please, David.
Thank you very much, Scott, for your overly generous comments. Iconic is not the word that comes to mind, at least in this household. So I want to say first that we at the State Energy Environmental Impact Center are really excited to be with you as a partner in announcing the release of this book. As some of you know, the State Impact Center is part of NYU Law School, and we're a nonpartisan legal center whose mission is to support state attorneys general in defending and promoting clean energy, climate, and environmental laws and policies. And I hope you'll visit our website to see the full range of what we do. Pertinent to today's press conference, we undertake academic research, hold workshops, issue special reports, and now publish books that we hope advance legal and policy analysis on energy, climate, and environmental issues of import, particularly to the state attorney general community. This book project grew out of a recognition that a number of very challenging mega legal issues that have societal ramifications are on our doorsteps. And state attorneys general are interested and or involved in all of them. Take, for example, questions about the liability of oil and gas companies under state law for potentially knowingly misrepresenting and failing to warn how their products could cause and exacerbate climate change. The liability of opioids manufacturers, formulators, and distributors for potentially knowingly misrepresenting opioids, high risks of addiction, which have destroyed so many lives. Liability issues around exposure to and cleanup responsibilities associated with so-called forever PFAS chemicals that stubbornly do not break down in our bodies or the environment. And looking ahead, how will potential liabilities associated with the global distribution of COVID-19 vaccines be handled? The emergence of these issues prompted us to look back at past mega health and environmental crises to see what we might learn from how those past crises were resolved and potentially assist advocates, judges, and legislatures apply those learnings to future crises, as Scott discussed. We were surprised to find limited cross-cutting literature on the subject. So we decided to go all in somewhat naively by producing a book the book we're announcing today, Looking Back to Move Forward, Resolving Health and Environmental Crisis. I want to give you just a few highlights from the book and then open it up for questions. As Scott referred to, the book's composed of 7 chapters that each take a deep dive into a particular health or environmental crisis and attempts to resolve it. Let me run down quickly the 7 chapters. The first 4 deal with health crises. First chapter is entitled Diethylstilbestrol and the Birth of Market Share Liability, written by Logan Page, and it traces the development of market share liability theory that enabled a group of women known as the DES daughters to recover for harms caused by synthetic estrogen prescribed to their mothers during pregnancy, despite the fact that the daughters were not able to prove which companies may have supplied the drug. Second chapter is entitled A Complex Achievement, the Tobacco Master Settlement Agreement, written by Joelle Lester and Carrie Cork of the Public Health Law Center at Mitchell-Hamlin School of Law. It discovers waves of litigation that culminated in the 1998 Tobacco Master Settlement Agreement, which still stands as the largest legal settlement ever executed in the United States, and its somewhat successful but also disappointing track record upon implementation. And I should note parenthetically, a lot of the lessons we're learning are lessons that we want to avoid going in the future. The third chapter on the health side is entitled Response to Vaccine Immunity, the National Childhood Vaccine Injury Act and its Consequences. It was written by Hampton Macbeth, a staff attorney at the State Impact Center and the book's editor. It explores the conditions that led Congress to adopt the Vaccine Injury Act of 1986 and 87 as a mechanism to compensate victims of faulty vaccines. And the chapter examines the statute's success in reducing vaccine manufacturers' exposure to tort lawsuits, but also its shortcomings as a method for compensating victims. Very important for folks who are thinking about setting up alternative outside the court compensation systems. Scott talked about the wonderful chapter that we have from ELI entitled Courts as Policymakers, the Uneven Justice of Asbestos Mass Tort Litigation. And I endorse Scott's comments that the authors, led by Sandra Cham and Carol Jones, Cynthia Harris, and Samuel Koenig, really point out the tragedy in many respects of the combination of the court system and the regulatory system and the legislative system and not coming to grips with this problem. The second section of the book focuses on 3 environmental crises. The first chapter in that section is entitled Superfund at 40, Unfulfilled Expectations, authored by Catherine Probst. It discusses the 1980 Superfund law and the amendments thereafter, which provide, as you know, a mechanism to fund for the cleanup of contaminated sites across the US. And it's been implemented now for 40 years by the Environmental Protection Agency, with lessons to be learned. Mixed success, but very interesting congressional involvement in establishing liability, and then later providing more transparency into the program. The next chapter is entitled Deepwater Horizon, authored by the State Impact's own Deputy Director, Liz Klein. It focuses on the forces and considerations that shape the $20 billion civil settlement among BP, the federal government, Gulf states, and local governments following the Deepwater Horizon oil rig disaster that occurred in April 2010. And it assesses the agreement's implementation record so far. Very ambitious and very important lessons there. Finally, the final chapter is entitled The Volkswagen Dieselgate Clean Air Act Settlement, written by John Cruden and Josh Van Eaton, both of whom represented the US as senior Department of Justice officials in negotiations with Volkswagen over the scandal. It explores the conditions that allowed for the amazingly rapid achievement of 3 consent decrees to settle the Clean Air Act claims that flowed from Volkswagen's deceitful practice of placing defeat devices in their diesel vehicles to conceal their true emission levels, which of course far exceeded legal limits. And as Scott mentioned, the book also has a synthesis chapter that I wrote. And it identifies 4 instructive takeaways that I posit from these 7 controversies and crises discussed in the book. I'm going to review those takeaways very briefly here. The first being, contrary to the popular perception, it's generally not possible and often not even desirable to try to pull together a global settlement that purports to resolve all issues associated with complex health or environmental crises. These difficult crises are more commonly resolved through individually important but not fully dispositive steps that create momentum and provide a solid basis for additional progress, often including complementary actions by regulatory and legislative authorities. Tobacco is an excellent example in that regard. The state attorneys general were focusing primarily on stopping the epidemic of smoking, not on compensating the victims. But their master settlement agreement cemented the company's liability. The discovery process uncovered evidence that the tobacco companies knew they were selling a dangerous product. That paved the way for successful follow-on class actions and injury suits against the companies. And it emboldened Congress to provide the Food and Drug Administration with unprecedented authority to regulate tobacco products. Second, parties seeking to resolve massive health and environmental issues cannot compromise on the basics. To have durable resolutions of these issues, the responsible parties must be held accountable, number 1. Number 2, the offending conduct has to be stopped. Number 3, victims need to be compensated. And number 4, damaged resources restored. The boxes don't all have to be checked at once, but none of them can be prematurely compromised. The responsible parties being held accountable is central to the success of resolving these issues. Sometimes that's relatively easily when there are few companies involved. The Volkswagen case, the BP case, for example, liability was clear. It's harder when there's a broader group of companies involved. But our book's case studies show how the laws evolved to prevent companies from shifting blames to others through the emergence of court-developed tort doctrines, like market share liability in the DES Daughters case, the increased use of product liability law to put the onus back on manufacturers, as with tobacco and then later with asbestos, or through congressionally confirmed strict liability principles, as through the Superfund law. The offending conduct must be stopped. That's number 2. We see that companies can be held to account, and then settlements can spread through the industry. We've seen that with Volkswagen, followed by Mercedes-Benz, followed by Chrysler and others that turned out they have also deceived the government. And then regulators in Congress can step in to broaden the scope of judicial settlements or strengthen the underlying law. Interestingly, it was the Exxon Valdez disaster in Alaska that led to the Oil Pollution Act of 1990, which provided the underpinning for helping to resolve the Deepwater Horizon disaster. Victims must be compensated, number 3. That can often piggyback on early liability determinations, as in tobacco, as in Deepwater Horizon. And then interestingly, as I alluded to before, there's often an interest in setting up a separate compensation system outside the court system. And the Childhood Vaccine Act chapter provides a cautionary tale in that regard. And finally, damaged resources must be restored. This is really a modern add-on to the stories that have been told in the past. I think Superfund had a big push in this regard, obviously, with calling for companies to have direct cleanup responsibilities, recognizing that We're not just talking about violating the law, but we're talking about the need to address the problem. Volkswagen had a huge element to it in restoring the Clean Air Act violations by promoting, in that case, electric cars, etc. Deepwater Horizon also has, in fact, $16 billion set aside to restore damaged resources in the Gulf. The third and fourth takeaways are very quick, deserve attention. First, the third being, you've got to have the support of the public to make these settlements work. One-sided resolutions will not stay in place. You cannot strong arm these things. These are, by definition, issues of massive societal interest. They're not going to be resolved without open ventilation of the issues in play. And finally, we see in these cases the enormous logistical and management challenges dealing with these nationally significant issues. As Scott referenced, they strain our legal system. The book shows examples, though, of where the courts have been able to make progress. John Cruden and Josh Van Eaton's chapter on the Volkswagen settlement, I think, shows in particular how the multi-district litigation process can sometimes rise to the occasion. Similarly, in the Deepwater Horizon case, much less so when it came to asbestos. So I'm going to stop there. I do want to thank the authors who contributed to the book, and a special thanks to Hampton Macbeth and his marvelous job as editor of this entire enterprise. And of course, to Scott and our partners at ELI. One final mention, we're going to have a webinar next week on November 18th at 3 o'clock. We hope you will join us then. In a very quick 1 hour, we are going to feature all of the chapter authors talking about the key takeaways from their chapters. So I'll leave it there, and we'll open it to questions. Also, in terms of, I think at the end, there's a place to buy the book. We kept it very reasonably priced. I think if you go on the ELI website or our website, the State Impact Center, you can find that information. And also there'll be I believe, a graphic on that shortly. So let me turn it back to Stephen.
Thank you, Scott, and thank you, David. David, you mentioned the webinar coming up next week, so I want to look a little bit backwards. The book is the culmination of the Health and Environmental Settlements Project. I wonder if you could talk a little bit about what else that project involved.
Sure. As I sort of alluded to, we backed into this book. We started with a workshop at NYU in March of last year, where we pulled together panels on 4 major settlements that included asbestos, tobacco, and the Deepwater Horizon. And it was out of that rich discussion that we realized that there had not been available really in one place a rendition of the key factors in these seminal settlement efforts. There have been some terrific, I should say, individual writings on the subject. John Cruden, for example, has written a couple of marvelous long articles, but we were looking to identify, not tell the whole story of how these issues developed, but provide a concise focus on the settlement process itself and the architecture of the settlements, and how that architecture has stood the test of time, whether it addressed the key issues or not. So that was the genesis of the project, and today we are all excited that we've reached the finish line here with the release of this book.
Thank you very much for that. That's the only question we have. So thank you very much, Scott and David. We'll leave it there for now. We encourage everyone to visit the State Impact Center's website to learn more about looking back to move forward. There's a link in the chat. And please feel free to send follow-up questions to me or Rachel Jean-Baptiste at ELI, and make sure to follow the State Impact Center and the Environmental Law Institute on Twitter. Our emails are there, and there's also at the bottom a link to order the book. And thank you for tuning in today.
Thank you, everybody.
Thank you.